I've known Elisa and her work for a long time, sort of by reputation. We first met actually last fall when we were on a panel together at NYU about copyright and fair use, and Elisa's about as well positioned as any artist I've ever met to talk about those issues because the work she does directly engages with our copyright laws in so many ways. Elisa's a Brooklyn-based video artist who creates pop culture remixes. She has mashed up Mad Men into feminists and The Real Housewives into lesbians, and her latest work includes sorry? Oh, awesome. That's really good. Excellent. Elisa's also been very active, as I mentioned, on issues related to copyright and copyright infringement, working on exemptions to the DMCA's anti-circumvention provisions as they relate to ripping of DVDs. She's a contributor to the Book of Jezebel, the upcoming Routledge compilation, companion to Remix Studies, and The Future of Now, Making Sense of Our Always-On, Always Connected World. And she is currently an artist in residence at Public Knowledge and the I-Beam Art and Technology Center. So without further ado, I'll turn you over to Elisa. And again, in typical format, I think she'll speak for a while, probably show us some examples of her work, and then we'll open it up to some conversation among all of us. So thanks for joining us.
Great, thank you. Thank you guys so much for having me here. It's so wonderful to be here at Berkman. I went to school at Simmons College, kind of in the area, and I learned how to edit video down the block at Cambridge Community Television, where I learned sort of the basics of media activism. So I'm so excited to be back here. I love the work that Berkman does, and so I'm excited to share my work with you guys. So I'm an artist and activist based in Brooklyn. I'm going to talk mostly about my experiences as a content creator using hosting platforms such as YouTube to distribute my work, and the policy issues that I found that was embedded in that seemingly simple process. Then I'll open up for discussion, and I'd love to hear about any of your experiences that you've had either as content creator, lawyers, advocates, policymakers, and just keep the conversation going. But in the meantime, I wanted to show you a quick example of my work. This is a video that I made last year in collaboration with another video editor, Mark Folletti. Is anyone watching Mad Men this season? Or like, have you ever watched it in any season? Okay, maybe, some, yeah, okay. So this was a remix of the women of Mad Men. I really wanted to see what an entirely female-framed version of the show would look like. So I took all the female characters out of the show and re-edited it into a version that re-articulates the feminist frustrations that the women felt amid rigid gender roles. And it's set to the 1966 Motown hit, Keep Me Hanging On.
Why don't you, babe, get out of my life? Why don't you, babe? You don't really love me. You just keep playing me on. You don't really need me. You just keep playing me on. You don't listen to me. You don't want to run with me. You just want to walk away. You don't speak to me that way. I'm just trying to do my job. I'm just trying to do my job, and you're making it very difficult. That's my job. I'm good at my job. I do my job. I'm so working on my job. Exactly. Why don't you, babe, get out of my life? Why don't you, babe? You don't really love me. You just keep playing me on. You don't really need me. You just keep playing me on. You weren't expecting me to be a man. My father was too. I never expected him to be any other way than what he is. I forgot for a second that you're incapable of doing something nice without expecting something nicer in return. It all comes down to what I want versus what's expected of me. Exactly. Why don't you, babe? Get out of my life. Why don't you, babe? Set me free. Why don't you, babe? Get out of my life. Why don't you, babe? You better stop talking now. If I were a woman, I would be allowed to ask you the same question. I am not your darling. I don't want your kisses. Is that a threat? Because I've already taken somebody up on one of those tonight. I chose to be where I am. I don't view it as a failure. And I am not scared of any of it. Set me free. Why don't you, man? Get out of my life. Why don't you, man? You don't really love me. You just keep me hanging on. You don't really need me. You just keep me hanging on.
Thanks. My art practice revolves around hacking pop culture, and that's something that is really meaningful to me. I love making pop culture hacks, using pop culture as a spoonful of sugar to make the socio-political critique go down a little bit easier. And part of the reason why I love hacking popular culture is because it helps me negotiate my own fine line between being a fan of popular culture and remixing helps me negotiate the fine line between being a fan of popular culture and being a critic of it. And so one of the things, like with Real Housewives, like I found myself really drawn to these women, and yet I couldn't turn off like the feminist filter that I had paid so much to learn in undergrad. And so how do I negotiate that fine line between like this feminist queer theory that I have, but also kind of wanting to turn that part of my brain off and indulge in popular culture? So pop culture hacking helps me combine the two. Did anybody see the Jay-Z 6-hour performance piece at Pace Gallery? Jay-Z went to Pace Gallery, which is a really sort of famous, well-known, reputable art gallery in New York, and said, I want 6 hours to take over your space, and I want celebrities there, and art world people and fans, and he did a 6-hour-long performance piece in the vein of Marina Abramovic. And what did he perform? Well, he performed his song Picasso Baby numerous times, over and over again. And so I just want to show you a quick example of that video. This is just the original version.
Concerts are pretty much performance art. The venues change. And just by nature of the venues, the performance change, right? If you're in a smaller venue, it's a bit more intimate. So you get you feel the energy of the people. Straight from work. In a concert, especially a large concert, all that energy comes to you. Like, what do you do with that energy? So today it's kind of an exchange. We have somebody to drop it back off. When arts are becoming part of the galleries, it became a separation between culture and even in hip hop, people almost like artists to bourgeois. We're artists. We're alike. We're cousins. That's what was really exciting for me, bringing the worlds back together. I try not to have any expectations going into a performance. I try to just let it happen. Just get into the moment and, whatever happens, happens. Turn it up a little more. I just wanted Picasso and my casa, on my castle. I'm a hot no, I'm an asshole. I'm never satisfied, get out my hustle. I want the Bronco, no, I want the Bronco, no, I want the white fucking life prostitute. Let's make love on $1 million in a dirty hotel with the fan on the ceiling. All for the love of drug dealing, marble floors, gold ceiling, oh, what a feeling. Fuck it, I want to feel it. I just want to blow up. Condos in my condos, I want to roll up. Christie's with my Missy, living the MoMA. Bacon, the turkey bacon, smelling your aroma. You messed up my whole flow, but I'm gonna get back. Oh, what a feeling. Picasso, baby. Picasso, baby. Oh, what it feels. Picasso, baby. Picasso, baby. Picasso, baby. Picasso, baby. Hard to tell.
Okay, so you get the point. So I saw this video online, and then it went up on HBO as like a 30-minute mini documentary as well. I couldn't watch this without thinking of another song that had come online the same week, which was a Taylor Swift song called I'm 22. And so when I watched this video, all I could see, and now with the sound off, you can kind of get the sense, you never see the art world this happy. You never see people so excited to be seen and recognized by a popular culture figure. The art world usually is happy to be underground and happy to be critical and happy to be, that's kind of what the art world does and is and how they function. They critique culture. So to be able to see these artists and critics and curators all in one place being so happy to finally be recognized by popular culture, it made me really want to make something more like this.
It feels like a perfect night to dress up like hipsters and make fun of our exes. It feels like a perfect night for breakfast at midnight to fall in love with strangers. Yeah, we're happy, free, confused, and lonely at the same time. It's miserable and magical. Oh yeah. Tonight's the night when we forget about the deadlines. It's time. Uh-oh. I don't know about you, but I'm feeling 22. Everything will be alright if you keep me next to you. You don't know about me, but I'll bet you want to. Everything will be alright if we just keep dancing like we're 22. It seems like one of those nights. This place is too crowded. Too many cool kids. It seems like one of those nights. We ditch the whole scene and end up dreaming instead of sleeping. Yeah, we're happy, free, confused, and lonely in the best way. It's miserable and magical. Oh yeah. Tonight's the night when we forget about the heartbreaks. It's time. Uh-oh. I don't know about you, but I'm feeling 22. Everything will be alright. You keep me next to you. You don't know about me, but I'll bet you want to. Everything will be alright. We just keep dancing like we're 22.
Okay, so that was obviously the remix version. Oh, thanks. So my goal always, either with the more complicated version of Mad Men Set Me Free, or this super simple pop culture hack, my goal always is to take 2 pieces or 3 pieces or multiple pieces of media that should never be in the same sentence together and combine them to make something new. Hopefully that's a little bit better than either of the originals. And so with that intent, I really enjoy talking about and studying the transformative aspect of remix video, because that, at the end of the day, is what makes remix interesting, at least to me, and legally that's what makes remix fall under fair use. So with that said, my work is highly eligible, I think, and I'm happy for other people to disagree, to be highly eligible to be considered a fair use by a judge if I'm ever sued, I think. Again, I'm open for feedback on that. But does everyone knows what fair use is, I assume, right? So, no. Okay. Oh, touche. Yeah. Well, for the purposes of this conversation, I think we can maybe agree that fair use is a safety valve in copyright law that allows for copyrighted materials to be used without permission for purposes of comment, critique, satire, homage. The important part, I think, is that at the end the work is transformative, and that it's not a market substitute for the original. So those are kind of the guidelines that I go by for fair use. Again, I'm not a lawyer. I'm an artist who just relies on this in order to distribute their work. But we can definitely go deeper into that later if you'd like. But for right now, I want to focus on the transformative aspect of the remix work. So when I started remixing in 2008, doing a lot of Real Housewives of like any city, just making any Real Housewife a lesbian, basically. No one really touched the work. It would go to YouTube. It would stay there, and I had very little trouble with it after that. And it wasn't until 2011 that I noticed that my videos were being flagged for potential copyright violations upon upload. And many times the video was available and playable, like here. It says your video is available and playable. It gives you the breakdown. So the Judy Garland song, it's kind of a mashup actually. That's at that comes in at 4:54. That was flagged as a potential copyright violation. My dispute was awaiting a response by 12:01, and then the audiovisual content was administered by Lionsgate, and then that was flagged, and that appeal was waiting response by November 18th. So immediately as I uploaded a remix to YouTube, I would get these flags, and I would have to spend about 15 minutes disputing the content. It wasn't that big of a deal, and it was because I kind of had my fair use, blurb, I could copy paste that in. And I was pretty sure that they were fair use, and so I didn't feel threatened by it at all. But while I spent the 3+ weeks waiting to hear back from the copyright holder, who ultimately has the final say in the matter, I noticed that ads were being placed on the videos. And you can see here, so this ad for North Face ran here and on the side. So these would run on the video, and all of the ad revenue would go to YouTube and to, in this case, North Face. And that, I have to admit, I was kind of angry about that. I saw my art practice as maybe, through maybe some fault of my own, a little bit more pure than that. I thought that my art practice was a more radical disruption of top-down culture production that threatened concepts of ownership. And the truth was, it did threaten concepts of ownerships, and that's what happened. So I began to see the reality of my unpaid labor as more of a sharecropper type model, where I was working in a system that allowed the user, me, to upload legal fair use content, but only in return for ad revenue. So, and this was under the best of circumstances, mind you, because most of the time, the content was removed. So that Jay-Z, Picasso, Baby, Taylor Swift remix, this is a screenshot. This is the copyright flag notice that I received. So you can see UMG says that they own the sound recording, and then the visual content is owned by Iconic TV. That comes in at 1:18, and then they show you the moment in time that Content ID flagged the video. So in a way, they were right. I mean, I don't own Taylor Swift 22. UMG does own it, but what bothered me was that there was no room for interpretation in this. There was no room for a safety valve in copyright law. There was no room for people who were making creative or innovative works to let UMG know that they had that right to do so. And so between the monetization and the videos being blocked globally, I have to admit, in the beginning, I didn't care so much. I thought, well, at least they're on Vimeo. They're somewhere. People can find them. People can share them. But then I realized, okay, first it's YouTube, and then it's Vimeo. Like, at what point in time do users advocate for themselves? And so instead of, to me, I likened it, again, this is sort of my feminist theory background, but like, you can go and like build your own utopia, right? Like, or you could stay and fight for change in the culture, or sort of in where you're at within the system. And to me, fighting within YouTube meant sort of fighting within the system to change the system that most users use. Not only that, but I began to really see the cultural impact of being blocked on the second most popular search engine. I started really to question what that meant for artwork that commented and critiqued popular culture. I thought, shouldn't that be in a really public space, not on Vimeo, where you can't find anything, even if you know the title of the video, you still can't find it. I really thought, even though YouTube isn't so much a public discursive space because it's privately owned, it's a public square on the internet. And I thought that it was really important for artworks, or just any content that critiqued popular culture, to be in the space where popular culture lives and interacts and comments. So even though I thought the work was legal, YouTube and copyright holders disagree. They kept tracking, monetizing, blocking the work. And I started to worry not only about the cultural implications for this, but I was talking to, going to schools and doing conversations about this and talks about this topic, and I realized that there was an entire generation of content creators who were uploading legal content and being told that the content they were making was maybe perhaps not illegal, but questionable, and that the legality of their work was questioned in some way. And what did that mean for fair use, a right that we all have but is continually threatened? So, of course, I didn't know the answers to any of these questions. And what was even more scary was that I began to think, do terms of service trump fair use rights? So when you're in this public space that you think is public, really, do your rights not apply there because you're within their terms of service, or you agree to their terms of service upon uploading? So obviously I didn't know the answers to any of this. Some of them I still don't know the answers to, and we can talk about later. But I teamed up with IBeam and Public Knowledge to do some research and look into this. And so it was a 6-month residency to explore the questions and how they apply to my work. And this is primarily what I found. So back in 2008, just as I was learning to edit video and uploading things and making mashups and uploading them to YouTube and not receiving any sort of legal implication for doing so, the hosting platform was receiving pressure from copyright holders who wanted an automated solution to detecting copyright infringements from being uploaded to the site. And so by 2011, they were testing that solution, and that was Content ID. And is anyone familiar with Content ID? I'm sure you're all familiar. Yeah, okay. So I kind of don't need to tell you, but Content ID scans over 400 years of video daily from more than 5,000 partners. Partners are basically copyright holders, including network broadcasters, movie studios, record labels. And so when there's a match, the content gets flagged, ads get placed on the content benefiting the copyright holder, or the video is blocked or tracked. And the information about this process isn't hard to find. Like, I really want to emphasize the information about Content ID and how this process went down is readily available, except that on YouTube and in the spaces where it resides, it's all geared towards advertisers and copyright holders. And I just want to show you a quick example of that. This is the video on the YouTube site that talks about Content ID.
No matter what kind of video creator you are, copyright directly impacts the videos you make and the way you use YouTube. Today, millions of people around the world upload their own videos to YouTube. They document world events, create home movies, and make their own independent films. And sometimes, even though it's against our rules, fans pay tribute to a new hit song they love. or their favorite movie or TV show by uploading videos to YouTube that use content created by others. So how can copyright holders identify these uses of their content on YouTube, control them, and even take advantage of these new forms of user distribution? The answer is Content ID, a system we've built that gives copyright holders choices about whether and how their content is shown on YouTube. Here's how it works. Copyright holders give us copies of their audio recordings and videos that they want us to look for on YouTube. We call these copies reference files and put these files in a database. This database contains over 3 million files, from pop songs to full-length movies. Every time you upload a video to YouTube, we quickly compare it against every reference file in our entire database, looking for a match. Content ID can identify audio matches, video matches, partial matches, and can even identify a match when one video's quality is worse than the other. Each time Content ID finds a match, we do what the copyright holder asks us to do with that video. Either block it, leave it up, or even start making money from it. With over 24 hours of video uploaded to YouTube every minute, Content ID works around the clock and scans over 100 years of video every day. It's like 36,000 people staring without blinking at 36,000 monitors all day, every day. Now, copyright management is easy and accessible for everyone. Artists can let fans reuse their content, and fans can create promotional and business opportunities for their favorite artists, making Content ID a true win-win that enables new forms of creativity and collaboration around the world. You can learn more about Content ID by going to youtube.com/t/contentid.
Obviously is great for addressing the legitimate piracy concerns that copyright holders have. I felt that Content ID also put fair users in a legal bind that made them the dolphins being caught while fishing for tuna. And so we want strong enforcement when people are breaking the law, for sure, but we also want strong limitations and exemptions when people want to and when they do create and innovate. And that was something that I felt was missing from Content ID and missing from the system in general. Specifically, Content ID misidentified legal fair uses of copyright content for infringing reuses, and I felt that this wasn't just a simple error. The effects are pretty great. It wrongfully teaches an entire generation of content creators that what they thought was within their rights as creators is in fact illegal, or again, at least questionable. And in my opinion, it highlights and exacerbates to an extent what the College Art Association found in a recent study. They polled visual artists, visual art professionals, and they found that academics, art historians, museum workers, publishers, artists themselves, academics, we were confused and misinformed about copyright and fair use, and that as a result, we specifically constrain and censor ourselves to avoid the confusion and resulting fear and anxiety when it comes to copyright. And so the self-censorship was, for me, a big red flag. So if artists are now self-censoring themselves based on their understanding of what copyright and fair use is, then that seemingly non-problematic upload system, Content ID system within YouTube has a very real effect for artists who are trying to create and distribute their works digitally online. And so in the end, at the end of the residency, I came to the conclusion that Content ID is a private agreement between a hosting platform, that is YouTube, and copyright holders, and in my opinion, undermined the safeguards for fair use that were built into the law. So as of 2012, over 120 million videos had been claimed by Content ID, and obviously there's no way to know how many of those were falsely claimed as fair use. I just want to make a note that this problem isn't, it's not just YouTube, first of all. I'm not out to get YouTube or Google, but it's also not just for people who are remixers who are using copyrighted content specifically in their user-generated content. Has anybody heard of the Rumblefish picking a wild salad case? So this was a great example of how there's two very different extremes on this topic. One I think is my end of the remix work, but then the other is the pure user-generated content. And that's what this gentleman did. He went out in his backyard and he literally picked a wild salad, put lemon on it, and ate it. And it's all shot with, I think it was like a flip cam. So this was back in 2012. So this to me is one of the most telling of the flaws embedded in the automated copyright system. So this is called Simple Living Picking a Wild Salad, and the user, Simple Living, documented himself picking a wild salad. As he states in the information section below his video, he says, basically their system identified this video as containing copyright infringing music owned by Rumblefish. They put ads on it, and with the proceeds of the ads going to Rumblefish and partly to Google. Since there's no music in my video, I disputed the claimed copyright violation, and Rumblefish was sent a link to my video to check and see if YouTube's automated system had made a mistake. They checked the video and told YouTube there was no mistake, and that they do own the music in the video. So the dispute was closed, and there was seemingly nothing else I could do. Now, what's not stated in that sentence is that the copyright music in question are the bird noises in his backyard. And that's what had set off the Content ID system, and that's what Rumblefish was fighting over, that they own the rights to. That last part, the dispute was closed and there was seemingly nothing else I could do, is both worrisome but an accurate description of how this process usually goes down. If you've ever uploaded just something to YouTube and tried to dispute it, it's a long, time-consuming process. It often takes 3 or 4 weeks to hear back from the copyright holder, and in the end, there's no guarantee that your fair use claim or dispute will be heard or that they'll agree with you. In the end, they choose the fate of the video. And so this is one of my favorite examples, unfortunately, because it illustrates that it's not just remixers or people who use copyrighted content like documentary filmmakers, people like that. It's everyday user-generated content that's also affected by this. Okay, so at the end of the day, I'm an artist. I've gotten into this dark, long rabbit hole of content ID and copyright and fair use. And I'm in this residency and I'm really struggling, well, how do I make this visual? How do I take this seemingly simple concept of sharing digital works online and the trials and tribulations that come with it? How do I make something visual with that? How do I visually explain how harmful these private agreements are? So YouTube gives you the exact frame that Content ID identified the video as a copyright violation. So they give you the time code. So this one is 150, and then you'll see there, if you can't really see it, but it says 150. They give you the exact frame. They say this is the frame that you have copyrighted material in. This is what Content ID identified as a copyright material, and this was the frame in which they had the grounds to send the flagged content and put ads on it or block it. So I took that image and I blew them up, and I had them painted into 36 by 48 giant oil paintings. And I put them in a gallery. There's one more painting missing from this, but I had them framed in gold. I had the video here for reference, so you could understand not only the transformative nature, but what the original product was, and place the frames throughout the gallery. And by frame, I mean the literal frame of the image, but also the physical frame. And so for me, this installation not only highlighted the hierarchy of artistic production. For example, you'd never go into a gallery and put ads over a painting, but you would with a YouTube video. But also for me, it highlighted that this frame now doesn't just represent Betty, it doesn't just represent Peggy and Joan. It represents, I hope, the exact moment that that private agreement affected a user on the ground, an artist who's trying to upload their content, someone who's trying to distribute their works online. And so that was the physical representation of this project. And so at the end, I ended up submitting a statement to the House of Representatives Subcommittee on Intellectual Property and the Internet regarding the takedown process. So the good news is that there has been some movement on this topic, and I don't know, people are looking into it. Well. But I think the take-home message, at least for me, is that policy has a direct impact on artists. And that's something I never realized. I got involved in policy work, but I never felt it on the ground. And so this was a great example for me as to how policy has a direct impact on users, on content creators, and how fair use is continually threatened. And fair use, obviously, you guys all know this. Fair use is a muscle. If we don't use it, we lose it. And so it's a safety valve that protects total control and encourages the flow and further creation of culture and artistic production. And so my goal is to make fair use easier to use when it's threatened. And so for me, I want to make it easier to defend our work online, harder for legal content to be removed for wrongful copyright violation. And again, at the end of the day, I think we all want strong enforcement when people are breaking the law, but we also want strong limitations and exemptions for people to create and innovate and make new, cool, and interesting work, whatever that may be. So thank you guys for listening. That concludes my portion, and I'm happy to take any questions and just keep the conversation going.
Frames of that video, was it from a YouTube video that was taken down?
Yes.
They blocked it. That one.
It really depends on at what moment in time. So this, let me point to them. This one I had gone through 3 or 4 disputes with this. So, but yes, it's the exact frame from the video.
But I mean, the video, YouTube blocked it.
Right, that was your question. YouTube put ads on this originally, and then blocked it, but only for like a week or 2, and then it was back up. It was all dependent upon who placed the claim on it. So Lionsgate, it was fine. It was up for like 3 or 4 months, and then another person put a claim on it, which was I don't think you can see it here, but Canal Plus. And then so it was blocked intermittently, and I just had to keep defending it to keep it back up, like issuing the disputes, or rather disputing the claim. Yeah. So but this one was blocked, but I think it may be back up.
Get it right. But so I've taught video blogging for years, and I've always told people to create their own content and not use copyrighted material. And YouTube, in their terms and conditions, say that if you are flagged for using copyrighted material three times, 3 strikes and you're out. So if people use it too much, they'll cancel their account. Is that still the way YouTube thinks of users?
Yeah, I mean, I'm not a lawyer and I'm not a YouTube expert, but in my experience, that is when you get a piece of material blocked and you're disputing it. So it's not for these individual claims. So when I say, if that makes sense, I know it's very leggy and very hard to understand because I'm clearly having a hard time explaining it. But that is only when the content is blocked globally. So that was like for the Jay-Z piece. And that's only if you're wrong, by the way. So the 3 strikes and you're out rule is only if you're incorrectly. Like if you say this is fair use and UMG disagrees, then that's a strike. But you can petition to have your strikes removed as well. So I think it always depends on the content. The problem with the private agreement is that it not only depends on the content, but who the copyright holder is. Because Lionsgate was totally cool placing ads on it, and they never removed it. But it wasn't until it got to Canal Plus or another copyright holder that that they had a private agreement to block it. So it's very hard to figure out what's the fate of the content, basically. And I should add that on the back end of Content ID, I don't believe that a copyright holder has to prove that they own the content. So that's why there's multiple claims against the content. Lionsgate obviously owns Mad Men, but Canal Plus does not own Mad Men. They're just a licensor. So it's not just the copyright holder, it's also the licensor, to my understanding.
I did a parody video of Hillary Clinton to the tune of Desperado, and I had an artist create new lyrics. And so the owners of the license for the Eagles' Desperado issued a takedown, and I was going to go against them saying it was fair use, but then I looked at their history of suing people, and they take all these things to court. So I ended up letting it
Yeah.
to stay off YouTube, but I put it over on Vimeo.
And did anything happen on Vimeo?
Nope.
Yeah.
But the point was that I wasn't parodying Desperado. I was parodying Hillary Clinton using the Eagles content,
Sure.
which really wasn't a parody of the Eagles.
Sure.
So it started getting confusing, and I gave up.
Totally. Yeah. I don't.
Because I didn't want to go
blame
to
you.
court, and
Yeah.
it would be very expensive.
Yeah. I hadn't heard that about court. I'm totally kidding. Of course, it would have been really expensive. Yeah, for sure. Yeah, no, I don't blame you. Yeah.
It sounds to me like it's fundamentally incompatible to have an automated system, which you seem to acknowledge is sort of a desirable thing to actually combat real piracy. And yet, since fair use is one of these things that requires constant human judgment on a case-by-case basis,
Right.
Well, it doesn't seem like you can do both those things.
Correct.
What do you propose instead, if
Yeah.
anything?
That's, YouTube hasn't come and asked me yet, so it's not, these are just my ideas that haven't been vetted by an attorney. For sure.
suggest to them?
So you know how Twitter has the verified account where you've got a little check and it means that you're either verified by the company you work for or basically no one can steal your identity, and impersonate you. I think a similar system within YouTube would be helpful. So that is a verified system for content creators or artists or people who are making similar work that is culturally significant, but clearly commenting and critiquing those copyrighted materials used. So it's not uploading a full episode of like The Daily Show. That would sort of be excluded from this account.
The kind of thing you do and say, she is not actually a pirate.
Well, I think that I'm not sure if they have the bandwidth to be human eyes, but some place where there was a fair use safe space for the content to remain online, at least until human eyes can evaluate it. So yeah.
Given the huge amount of stuff that's uploaded to YouTube all the time, and frankly, YouTube's desire to not lose a safe harbor protections to be sort of looking at things individually, can there maybe as a starting point be some sort of percentage of what's infringing versus the overall length of the video or something? Can there be, because there's no mathematical yellow line or bright line, but as a starting point, if it's maybe under 10% of the overall content, maybe Google could verify its content ID system or change it in such a way that if it isn't like a gross sort of appropriation, there's something small within that. It's a 5-minute video in 4 seconds or something infringing. Maybe that could be a way for them to deal with this, with the fire hose of stuff that's being uploaded and sort of the impossibility of human beings looking at it on a case-by-case basis. But it seems like it's fair use is so deliberative. And the uploading is so massive, I just don't see how anybody could go through this and make a fair use determination on a case-by-case basis.
Yeah, I think that's a great example of how difficult this process is. I see a number of problems with the excerpt times. First of all, it doesn't anything transformative or anything that, especially with the
It wouldn't be like a 100% batting average, but just some way to begin to address this issue. As opposed to this sort of a zero-sum game right now.
Yeah, I'm not sure. Yeah.
Instead of attacking the issue from the code writer's perspective, perhaps the dispute resolution perspective, and the Olympic Committee, U.S. Olympic Committee, and the IOC actually offer an example. I've done a lot of work for the U.S. Olympic Committee. When we have disputes between athletes and promoters and the national governing body, in the past what happened is that the national governing body would make a decision. Yes, you're eligible. No, you're not eligible. The protest ends. But what we've had to do is have an independent third-party sort of appeals, and maybe that's what YouTube and Google has. But instead of YouTube relying upon the interpretation of the copyright licensee or copyright holder making that determination, that somehow public pressure is put on them, that they create a third-party appeals panel, the people independent of the copyright holder, independent of YouTube and Google, perhaps appointed by each, and they actually hear these closer calls, because a lot of them are close calls.
Mm-hmm.
And I don't know if you're familiar with Woody Guthrie, but years ago he said something that applies, I think, and may be helpful to you. and that is, he said, related to this sort of issue of remix, he said, sing high when they sing low, sing fast when they sing slow. And you certainly did that in your first video, and less so, obviously, when you just parroted the Taylor Swift video.
Yeah.
Ask you what you think of when you're thinking of real copyright infringement or really breaking the law. So you mentioned, an episode of The Daily Show, and I agree that's fairly clear-cut, probably. But fair use is not often clear-cut, and it's both bigger, I think, and narrower than the, working definition that you gave at the beginning. So it seems to me that there's a lot of stuff that could be art that would also not be fair use. And I wonder how you reconcile that with you've sort of been drawing this bright line that I don't think exists
between a copyright infringement and a fair use.
Well, yes, yeah, a copyright infringement and art that should not be chilled or taken down.
I think it's a difficult. It's who's to even make that call. I think in a lot of circumstances, like I don't know. I think just like with any sort of law or legal theory, it's all up for interpretation at the specific time, judging by the cultural context. And so I think the definition of fair use now, my definition may be a little bit broader, or the definition of a copyright infringement may not. I also don't think a copyright infringement is that clear cut either. Like if you were to upload a full episode of The Daily Show to YouTube, it could be because you need to bring it into class to have a conversation about it. Like I'm not a lawyer, and I don't know if legally, like I have the understanding of the legal process to like defend that if I had to, but that I have no idea. I don't know, to answer your question. Like I think they're all up for interpretation, and that there is no definition. Is that too philosophical of an answer for you?
Right. I'm definitely not asking you to get into the legal question. I'm just wondering, the only way we know if something is fair use or not is if a court has ruled on it, right? And so that means there's going to be a lot of stuff that a court doesn't rule on or hasn't ruled on yet on YouTube, and it's like I wonder if you think that stuff should remain up until a court rules, or if the artist is unwilling to go to court, maybe it's okay if it's down.
Yeah, I mean, maybe there should be like a holding cell for. No, I'm serious. For content that is flagged by, that's up for at least that there'd be a spot for conversation about the content, and that's really what I'm looking for and asking for. I'm not sure that I have an answer that's gonna directly answer your question, but because I've never thought about it before. But if there's a spot where users, at least a safety zone, where users know these are their rights and this is what they're being held against, to compare it against, then they know at least what they're sort of in for. Does that make sense? I guess I'm looking for more transparency around what the rules of YouTube, what the law, what the YouTube rules of the code of conduct is on YouTube versus what my rights are as a user. So if there's a space like a holding tank, a holding cell, whatever, of a middle gray zone for that conversation to happen, then that would be great. So should all of them be, back up on YouTube if they're flagged for copyright violation? No, certainly not. But I think that the majority of those videos, if they were to be taken to court, I think that a court would be fair use friendly towards them. A lot of the content on YouTube is transformative or is being flagged for wrongful copyright violation. I'm not sure how many times you land on this video has been removed for copyright violation, and you read the description of it, and it's a user-generated content piece that had the bird noises, and I go back to the bird noises because that's a lot of the stuff that at least I come across just while surfing. And that, yeah. So does that answer your question? Okay.
So the part where it's like the artist versus Sony Music's lawyers is the part where we keep losing this, right? Because the artist isn't going to go to court most of the times.
Well, yeah, but not only, well, the art, yes, but I don't think Sony, like, there's only 2 or 3 cases at least that I know of where a copyright holder has taken someone to court over a YouTube video. Right? Does anyone have, like, exact numbers on that? By my counting, it's 2 or 3. The woman who has a happy birthday song, right? That's, like, the famous case, and then 1 or 2 more. So I don't even think it would get that far that the artist has the opportunity to say, oh, no, I don't want to go to court. Because the DMCA would never come. That
the artist can file a counter notice, right? So if you get to the point that the
but you're assuming
guy got to, he could have filed a counter notice, and that's kind of like saying, I'm willing to go to the mat on this.
So one of the proposals has actually been that you could preemptively give notice, like, I'm uploading this video and I think it's a fair use. Someone might come after me, but just consider this my counter notice, leave it up, and then if they want it down, they have to sue me. Do you think, so that sort of takes it out of the realm of let's sit in the holding box until YouTube tells us what our rights are. It's like, no, I have rights. And if we're going to have someone tell us that I'm wrong, it's going to be a judge.
Yeah, I like that.
What's
should
necessary to make that
I don't know.
work? I mean, for a creator like you, who's sophisticated about this, you would know to flag it. But for the amateur creators and fan creators who are like, oh, it turns out that was illegal, that's too bad. What's necessary to make that system work?
Well, I think if there's a system like that in place, then word spreads fast over YouTube of like massive takedowns of content. Like I don't know if you remember a couple of months ago when a bunch of gamers' content got removed for third-party content violation, and they were making the content with the copyright holders, like they were YouTube partners. And so when things like that happen, it creates a cultural sort of informal education process. And I think that if that were to happen, if there was that sort of preemptive program, that the culture of YouTube is such that that would be the education process. Like, do you remember when YouTube made that copyright school? And that's where people were starting to get their copyright education from, but it didn't really get very far because people didn't understand it and it didn't speak to their community base. In a situation like that, I feel like that would be a perfect example of actually communities would sort of self-teach themselves how to do that. So the fans, for example, would take note from the remix community, and then from there, I think it would be sort of a domino effect. The same way it was a domino effect with the gamers. And that sort of shed light on the Content ID process. Does that answer your question? I think. But I don't think an educational tool from YouTube would help. At least the history, historically it hasn't. But I really like that idea, and I wonder how we make that happen.
Well, it would require a change to the DMCA safe harbor provision, because at present, when they get the notice, they have to take it down, even if the user has already said, no, it's fair use, don't take it down. So it's something to take up with Congress as they think through their next copyright.
Yeah, and I think that's a great, not that we needed more reasons why the DMCA needs to be revised, but that's a great example of not just like, this is the problem with the DMCA, but here's a solution that's being hurt by current DMCA practice. Yeah.
One of the things this is me thinking aloud. One of the things you had mentioned was that it was unknowable how many of the however many millions of videos are, might be protected under fair use harbor. But if you could actually scrape them, it's totally knowable. You just need a random sample of maybe 2,500 or something like that, and then you would need to have some group of reasonably well-trained people go through them. But probably in a quick pass, you could it seems like one sort of issue here is like, how substantial is the problem? So if in fact, if there's in fact one dolphin and there's billions of fish being captured, then as a society we might look at this and be like, well, there's one way to solve this. We looked at them and half the things being removed, we're like, no, these possibly have some kind of legitimate fair use. We might think very differently. I don't know, just sort of thinking out loud. It seems like with some resources, and particularly like if you could somehow work with YouTube or just use spiders or whatever to find some reasonable population of takedown videos and then randomly sample from them, you could actually figure out, what the scale of the problem is. So somebody at Berkman should do that.
Yeah. My only question with that is, how do you do that if they've been removed?
Somehow you'd have to get like the original. You'd have to sort of somehow find like the original population, or work with YouTube and say, YouTube, give us access to,
All of
for the
removed
last year,
content.
for the last 5 years, like, just let us find a random sample of these videos to look at,
Right.
And then get a bunch of retired trial judges who trust their judgment, and just
Remember,
go through them and say like,
Recently retired.
recently retired.
Do you remember YouTube?
Yeah.
Like, I feel like they did that. They did that really well. But if you try and search that content for fair use content, first of all, it's really hard to search for anything.
Yeah.
But they did that pretty well, and that was by MIT. That was like an MIT project, I think, at the Media Lab.
What was it called? The free code?
Yeah.
YouTube, like
TOMB.
TOMB.
Oh, right.
Yeah.
But point taken, for sure. I mean, they didn't do what you outlined, but it was a visual representation of the number of videos that were being removed from YouTube. But I think that was made in 2010. You may know better, but well before the official Content ID system had been put into place and tested and gone forth and, put into full effect. Yeah.
It's just one potential area for hope. YouTube used to take down all of human rights graphic violation videos of torture and things because, it's not really public space, it's a private platform.
Mm-hmm.
And a lot of terms of service battles end up being good taste, not what's legal, right?
Mm-hmm.
So Facebook and breastfeeding and other examples. But then they end up working with Witness to,
Right.
put up an age, filter, but then to allow these human rights torture videos to stay up because they're important for spreading awareness.
Mm-hmm.
And they also actually built out the facial blur feature for activists.
Mm-hmm.
And it's another thing that they can do
Right.
algorithmically, so it's not this like legal question, but it is something that Witness worked with YouTube engineers to help them do. And so I was really curious about how do you get that influence at YouTube? There's lots of nonprofits that would love to work with YouTube. And so some people that used to be at Witness actually talked about this and wrote a blog post about how they were actually invited to give a tech talk at Google where they kind of introduced the question and got some people wheels turning, and that was kind of some access to engineers. And then someone pulled a fire alarm, and during the fire drill, they bonded with a couple engineers. And it was just like, so all we need is pull more fire drills. But there is some hope there of like over years, they actually built a trusted relationship where they could work privately behind the scenes to introduce these features. And I'm thinking that might work better than, because I remember like even back in 2006 when Google acquired YouTube, I think it was 2006, like the huge question was copyright, right? Like all the record labels were coming after them. People thought it was a dumb acquisition because of that. And so they were definitely responding to a wave of legal pressure. And so if there's any way we can like carve out a little space for free culture within that wave of legal pressure.
Yeah, agreed, totally. I think one of the things that's missing from this conversation is also just the lobbying power that users have over content and copyright holders. And so exactly in that conversation that happened in 2008 or whenever in 2011, where copyright holders said this is a big problem for us, there probably weren't users in that meeting. So the balance of power is a little bit skewed, and I think that part of the conversation is just about being a little bit more transparent in that process and balancing that power dynamic with that probably being behind the scenes for sure.
Any work with youth around or create workshops off this? Because like I see your work as like a bridge between making fair use and copyright real for a wider audience, the people who aren't coming at it from a legal perspective. And I think this is like super, super important, something that, legal experts or researchers often are like, why can't we get more people to understand the importance? Like Pip and Sopa shouldn't just be like the one big event, but it should be a continual thing. So it makes, and for like a pop culture fan like me, this is really inspiring that I now have another reason to watch Housewives. But
only if you make a subversive
I
video.
will now.
You gotta work off your consumption.
But is there a way, are you using this as a platform or a way to get more youth involved, because it brings together all these different skill sets?
Yeah, for sure. I did
not
a lot
just youth, but adults.
Yeah, I do. I definitely do workshops on it. And I tried the fair use component. Obviously, isn't as detailed as today, but it's definitely a component of it for sure. I think any conversation about user-generated content or content creation with the intent to distribute on the web, which like what kind of other content creation is there? You have to have a fair use component to it. And so it's not just for Remix, but I think anytime anybody's making content, it needs to be part of the conversation. And I've worked with I started actually working with youth at Cambridge Community Television and teaching fair use and copyright stuff to them. But I was really appalled. I don't know if I should say this. But when I walked into Cambridge Public Schools, they had a sign on the wall that was like, don't ever use anyone else's content. Always make your own. Like, be original, be yourself, you know, only make original content. And it was, not that there's anything wrong with that, but there kind of is something wrong with that, which is that it ignores an entire section of rights that creators have and people have to comment on culture, and that was being washed and erased by encouraging purely original content, which, like, what is original? There's nothing really original. But again, that's like a theoretical conversation. Yeah, it's a great segue to talk about youth and educate them on fair use. My problem is that I get tripped up a lot, and they start asking questions, and I don't know the answers to them, and I'm like, I'm not a lawyer, I don't know. So that's my own thing that I have to get over and find a way to talk about fair use that it's super succinct, to the point, and is a clear yes and no. But fair use isn't like that. So that's where I have a concern about talking about it and coming from that educational aspect of it. But that's not to say that that's totally stopped me from working with youth.
Well, I think it's really model that researchers should think more about, like working with artists, is a clear model of like not making or education didactic around these topics, but making it really creative and fun and approachable, and something I don't think that we do a good enough job at, you know. So you're a really great model for that.
Cool. Yeah.
So I'm wondering, here you basically have shown how you use art in order to challenge the application of copyright law, the way in which it is enforced. So I was just wondering whether you also make, or if you know anyone else that is making art in order to actually challenge the conception or the drafting of copyright law.
Yeah, so artists who are making work that challenges copyright? Yeah, I mean, tons of artists. I mean, the most recent is the Richard Prince Carew case. And I think that settled out of court, I think 2 weeks ago. So that's the most recent case. A ton of a lot of artists. Let's see, a few that come to mind are, can I get back to you? I'll send you some links. I don't have them all on top of mind, but the Richard Prince one obviously is the first that comes to mind. I don't know. I'm sure you got, who are other artists that?
Jeff Koons.
Yeah, Jeff Koons, yeah. Shepard Fairey,
Bob
totally,
Dylan.
yeah.
Bob Dylan.
George Bush.
Yeah, oh my gosh, for sure, yeah. I would love to talk about that. Yeah, the Shepard Fairey one was a good one. Negative Land, for sure. I mean,
you only basically challenge the enforcement.
Honestly, I didn't start off doing any of this. I just wanted to work off my massive consumption of popular culture. And this was just sort of a byproduct of, I was spending so much time defending my work online, I wasn't making any new work. And so I had to make new work to show in a gallery, and this became my life. Defending my work became my art practice. And so this wasn't the original intention. And I think for a lot of artists, it's not the original intention, maybe a byproduct or a subtle thread that runs through their practice. But I think that a lot of artists use popular culture for the critique, not so much, well, I don't know. I think Negative Land does a lot of copyright stuff for sure, but I think it's always part and parcel of a larger concept. But yeah, I'm happy to share some other artists with you. There's a great artist had a show that just closed in New York where he redid all the Andy Warhol pieces, but with new logos. So I should be more specific. The Campbell soup cans, but with 2014 logos. So there's great examples like that. Unfortunately, a lot of artists have the same problem where they can't upload their stuff online or to YouTube. So I can send you links, but there aren't that many images of them. Yeah.
It really seems like we've got a problem where the law isn't where we want it to be. That, you know, we have a long tradition of taking, saying that if you have an entire piece of music like a Taylor Swift song, you've got to get a synchronization license if you want to put it up against a video. We've got the court cases that say that taking a few seconds out of a piece of music for a new hip-hop work and sampling to create a dramatically different work and transformative work is a copyright violation and is in the way, and then you stick in a company like YouTube that's got what did you say, 24 hours of video being uploaded every minute, and trying to deal with some way of avoiding the worst thing. So in an uncertain legal environment and this massive fire hose of content, I'm not sure what the solution is. That in some ways having maybe the content ID with YouTube's improved appeals processes is the way to go. So a long way to get around a question. You had some videos taken down from YouTube, and did you go through the counter notice process and have those things get put back up?
Yes, I've gone through the dispute process and then the counter notification process. It takes about 3 months on a good, and that's a good schedule. It's a long.
It's supposed to be 10 days.
Yeah, that it does not take that. I mean, I can actually.
10 days they don't put it back up. If you file a counter notice.
No, it often takes quite a long time. Now you're talking about a counter notification, so that's the second step.
Where it's gone, because they leave these up when they're being questioned, right?
They leave
like these right now that say that
the copyright notice
has that somebody's claiming copyright in it. That's still accessible, and
yeah, it depends on who's claiming it. So this one is Canal Plus, and it says your video is blocked globally.
Oh.
And this one is Lionsgate. This one I believe was still playable. It doesn't say it on here.
So the video is blocked globally, and then you file a counter notice to put it back up.
Yeah.
But when you get to the end of the content ID process, you can still then proceed under the DMCA, right? And I think that's what Peter is asking
Well, no,
about.
even under Content ID says that you file a counter notice and that they will respond within 10 days. They're using the model of the DMCA now for Content ID.
In my experience, it's been a two-step process.
Okay.
You dispute the claim, the original copyright notification, and then the copyright holder either disagrees with you and issues a counter notification, and then you issue a counterclaim. And so that's the two-step process. And then after that, if they disagree with you, which in my experience with the Jay-Z video, they didn't disagree by the end of the second process, but it took 2 months to get there. And so by the second...
And it was down for the entire 2 months.
It was down for the entire 2 months, correct.
But then they left it up.
But right, and so because at the end it was the DMCA had to kick in, they had to take me to court in order for them to keep it down. But again, I need to emphasize that that process is not simple, and it's super scary, and they encourage you to find a lawyer, which perhaps rightly so, but it's not very user friendly. Let's put it that way. And I have some screen grabs of what that process looks like, and sort of how a user would go about that. And as an artist alone in their studio at 11 o'clock at night receiving this email, trying to go through the process of getting the video back up, it's scary. It's definitely scary, and if I didn't understand, have at least a working understanding of fair use, I'd be like, forget it. I'm totally not going to put up with this. Because it wouldn't be worth it, I think, to the user to defend their work, and that to me is scary.
I think we have time for one more question, and I think Elisa has a little time to stick around afterwards if people want to continue the conversation outside this room. So one more question.
Okay, well, I spoke already, but if there's no other question, I'll go. You said Vimeo has a different process that seems to be more friendly to artists. Well, why is that? How is it that they get to do things differently and it works better for you? And
they just don't have copyright holders coming knocking at their door saying that people are uploading pirated or copyrighted content to their site, and so there's no incentive to install or create a content ID system.
Not care about because it's number 2 and not number 1 at a video sharing site?
I think that I don't know, but from what I've heard from Vimeo's team is that they are in conversation with copyright holders, but they're trying to deem themselves a fair use friendly space, and so before issuing takedown notices or flags or whatever to the creator of the content, they're trying to deal directly with the content holder. With the copyright holder on behalf of the content creator. And so that to me is my understanding of Vimeo, but the basic answer to your question is I don't think that it poses the threat that YouTube did to copyright holders.
Model that might be.
I think they're working on an alternative model, and I think the reason why they're so popular is because they're a safe space.
Difference is who their customer is. I mean, I think I don't know exactly, but a huge part of the Vimeo customer base are people who pay some annual subscription to be able to host their materials there. Whereas YouTube, their primary revenue source is advertising. And so really it's the advertisers that it's mostly the content holders who are their customers.
Yeah, I had the exact same thought. When I asked them about it, they actually said that the majority of their content now is actually user-generated content similar to similar to YouTube. So people shooting like videos of their holiday parties and stuff like that. It's actually not, somebody sharing a file who works at an ad agency or whatever it may be. But I had the same thought and was corrected on that. I don't know if that's true. That's just what they said.
Join me in thanking Lisa.
Thank you guys. Thanks for those questions.